Hello, how are you? I hope you all are fine. Today we will be discussing about the new laws passed by the Parliament of India on 1st of July 2024. So these three new criminal laws are Bharatiya Nyaya Sanhita, it replaced IPC, Bharatiya Nagrik Suraksha Sanhita, it replaced CRPC, and Bharatiya Sakshi Adhiniyam, it replaced Evidence Act. The Evidence Act was earlier passed in 1872, and this IPC was passed in 1860. So these were very old laws passed during the British era. These need to be changed according to the new circumstances prevailing in India. So Parliament of India changed them, and new amendments have been introduced. So totally the names of these three laws are now changed, and many of the provisions are also changed. So Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suraksha Sanhita, and Bharatiya Sakshi Adhiniyam are the three new criminal laws which are now being implemented throughout India on 1st of July 2024. Basically, Hindi words are introduced in these laws. Earlier, most of the words, important words, were in Urdu language, important words. If we consider the Hindi version of the earlier laws, so Urdu words were used, but now Hindi words are introduced in most of the areas or sections of these new laws. Some of the important terms which are being introduced are mob lynching, terrorism, organized crime. A terrorist act has been defined in this new Bharatiya Nyaya Sanhita, and it is defined as if one is intending or likely to threaten India's unity, integrity, sovereignty, security, or strike terror in the people, in the minds of the people. So that is a terrorist act which can be punishable under Bharatiya Nyaya Sanhita. Earlier terrorism was under UAPA, but now also it is in UAPA, but additionally besides UAPA, terrorism or terrorist act has been defined in this Bharatiya Nyaya Sanhita also. So mob lynching is also one of the second offences which is punishable by death or life imprisonment if 5 or more persons commit mob lynching on grounds like race, caste, community, sex, place of birth, language, and personal belief. And one more important thing which is introduced in these laws is if a person who is a first time offender and he spends at least third of his jail term in jail, then he has to be released on bail, because already he has spent his 1/3 term in jail. So then the important thing is that in most of the investigations earlier, forensic experts were not used, or forensic technology is not used earlier, but nowadays in these laws most of the emphasis is given on the forensic investigation, forensic experts to be used in every case where the punishment is basically more than 7 years, and electronic evidence, digital evidence has been given very much due importance by the new laws. So they are to be treated as more important than documentary evidence. So digital evidence, electronic evidence, whatever evidence the police or the investigation team gets during the investigation. So whatever messages in the mobiles or messages, WhatsApp messages and Facebook messages, all have a due weight nowadays, so they can be considered by the court. Obviously if they are not manipulated or they are not tampered with, and it is cleared, and it is during an inquiry it is cleared that these are the authentic messages, then these messages or these evidence can be taken into account and judgment can be passed based on these evidences, because it's an electronic era, it is an IT era, so these evidences are very important. So basically in these laws most of the changes are on those sections which are very much redundant these days, and there is no need of those sections in this present era. Baki states are free to introduce their own amendments in Bharatiya Nagrik Suraksha Sanhita. For example, Punjab state or Haryana state, if they want to change any of the sections of the Bharatiya Nagrik Suraksha Sanhita, they can change them. Now, what about the cases which are registered before 1st of July 2024? So those cases who were registered before 1st of July 2024, they will run according to the old laws. They will run according to the CRPC or IPC. So those cases who are or which are filed after 1st of July 2024, they will run according to the new laws, that is B Bharatiya Nagrik Suraksha Sanhita, as far as procedure is concerned, and as far as the punishment and all these things are concerned. What is the definition of that offence? What is the punishment of that offence? Is it bailable or not non-bailable? It is cognizable or non-cognizable? For that, Bharatiya Nyaya Sanhita will be used, not IPC. But for those offences which were committed before 1st of July 2024, IPC and the CRPC will run concurrently along with B Bharatiya Nagrik Suraksha Sanhita and Bharatiya Nyaya Sanhita. EFIR, zero FIR. In earlier video I have already told about EFIR. So EFIR has been given due emphasis. Zero FIRs have been given due emphasis in the new laws. So one need not to go to police station to register an FIR. They can register the FIR online. So there is a CCTNS. It means Criminal Tracking Network System. Through CCTNS, without needing to visit a police station, one can register an FIR. So training have been imparted to various police personnel of various states to adapt according to the new system. So mob lynching, terrorism, terrorist act, all these things are defined clearly in the news, in the new Bharatiya Nyaya Sanhita, and where the punishment is up to 3 years. Summary trials are being introduced in Bharatiya Nagrik Suraksha Sanhita. So it is aimed to resolve at least more than 40% of cases in session courts. Videography has been made compulsorily in search and seizures during investigation. So the police investigation team can use videography as an evidence. So it is very important, and it has been made mandatory. No charge sheet will be valid without such videography. Videography has been made compulsory in the investigation, and when the police will file a challan or charge sheet in the court, it should be having a videography of the crime scene. Then as I've already told you, forensic experts will be used extensively. Basically, if the offence is having the punishment more than 7 years in Bharatiya Nyaya Sanhita, because punishment is given in Bharatiya Nyaya Sanhita. Bharatiya Nagrik Suraksha Sanhita doesn't give the punishments, it gives the procedure of trial. The punishment is given in Bharatiya Nyaya Sanhita. It is a substantive offence, a substantive law, and Bharatiya Nagrik Suraksha Sanhita is a procedural law. And a victim-centered approach has been introduced in these laws, but there are certain controversies like during police investigation, this extension of police custody. It has been extended from 15 days to 90 days. Earlier, the police custody was of 15 days, but now it has been introduced that it can be up till 90 days. So, a lot of police powers have been increased, and most of the social activists and the lawyers are against this. So, this is a controversy regarding this, that why the police powers are increased so much extensively, and now they can keep the accused with in the thana or the police station up till 90 days for investigation. So it can be misused by the police. So I think this has to be changed, because 15 days custody was enough. Then there is a repeal of section 377, unnatural offense, but now if there is a rape of an adult man, for that there is no section in Bharatiya Nyaya Sanhita, because if the word rape doesn't only mean that rape of a woman. If there is a unnatural sexual offense against the man, it should also be there should also be some section about that. So if section 377 of this IPC has been amended, or it has been repealed, some other section should have been introduced, and especially introducing the important aspect of our social life is that if a male person is sexually abused, so what about that? So for that also a lot of discussions are going about. I think new section will be introduced. So these were the important things, and one of the most important thing is that court have to give rulings within 45 days of the completion of the arguments by the lawyers. Once the lawyers have completed their arguments in the court of law, the judge has to give the judgment or the final decision within 45 days of the close of the arguments. So earlier there was no time limit. Now due to which there was a lot of delay in the decision, and the case prolonged very much. So now the judge has to give the decision within 45 days of the close of the arguments on the both sides. And as far as police investigation against women and children is concerned, it has to be completed within 2 months. Yes, within 2 months the police investigation, especially the crime is against the women and children, the police investigation has to be completed within 2 months. Death penalty has been prescribed for gang rape of a woman aged less than 18 years. So if the woman is less than 18 years, she is a minor, and she has been gang raped, then death penalty has been prescribed for those persons who has committed this gang rape. Sedition section has been abolished, but a new section punishing acts endangering sovereignty and unity and integrity of India has been created. So it's a rehash of the earlier controversial sedition law. Then there is a trial in absentia of the fugitive criminals who to whom the police is not able to catch hold of them. So judge can rule on these cases, and the punishment will be carried out once the person is found out. Then, as I've already told you, whenever there is a police raid or police investigation, they have to videograph the whole thing, and forensic experts has to be mandatorily used there. They have to mandatorily visit the crime scene for serious offences, especially those offences who are which contain the punishment more than 7 years in Bharatiya Nyaya Sanhita. Emails, server logs, messages, the WhatsApp messages, Facebook messages, all these things are to be given due importance, but proper inquiry should be there whether they are authentic or not. If after inquiry they seem to be authentic, then they have to be considered, and the court will admit them as an evidence. The most controversial provision is the extension of the police custody from 15 days to 90 days. So the lawyers are against this. It can extend the police powers to a large extent, and they can misuse these powers. So these were the important things of the new laws. Any other thing that is very important? Nothing more than that. This is a very short video for this, and most of the police personnels are not aware of these laws, and even lawyers are not aware of these laws. So they must be given proper training, so that during investigation they should not face any difficulty in implementing these new laws. Thank you very much.